Mr. McLoud has refused to accept mail from the court. We sent a mailing to him with copies of the orders that I entered at the last hearing. It was sent back to us with a red marker stating return to sender and offer to contract is denied. So sadly, Mr. McLoud seems to be retreating back into nonsensical sovereign citizen defenses. And he filed a document, or there's a document purported to have been signed by him entitled Letter Rogatory for Relief, that is legal nonsense that somehow accuses the court of somehow generating funds from the case using defendant as some security mechanism, which makes no sense at all. This is not the first problems we've had with Mr. McLoud, and now he's choosing to refuse service from the court and refusing to attend here today. We have a jury trial scheduled August 8th and 9th. Mr. Juliet, any requests from the people?
This is his first failure to appear, to my knowledge, but I wasn't aware that he was deliberately refusing correspondence from the court. So based on that, I would ask for a bench warrant. All
right, Mr. Wergo, any input from standby counsel?
Yes,
you don't represent him, but you're here to stand by and give him, you're here to give him advice if he is here, if he wants advice, and to stand by to represent him if he's not able to represent himself, and him not being absent, I guess, if you want to say anything on his behalf, I'll let you.
Yes, Your Honor. Being that it is his first non-appearance, and it appears that he is maybe under the impression that there are some legal mechanisms at play that aren't, I would ask that instead of a bench warrant, the court issue a show cause and allow our office an opportunity to try and work with him.
Well, he's not only not here today, he's refusing to accept anything that we're sending him. He's repeatedly demonstrated contempt for this court's authority and process. I'll issue a bench warrant for his failing to appear with no bond. Do we leave the trial date on for now, Mr. Juliet?
Yes.
Okay. Normally, I would cancel the trial date. I'm going to give Mr. McLoud the courtesy of not canceling that trial date because I don't want him to be sitting in jail for a super long time. Since the last hearing, Mr. McLoud has refused to accept mail from the court, sent a mailing to him with copies of the orders that I entered at the last hearing. It was sent back to us with a red marker stating return to sender and offer to contract is denied. And our first case this morning is People v. Trevor McLoud, file 23-6748FH. All right, Mr. McLoud, do you still desire to represent yourself, sir?
Yeah.
All right, and I'm required to remind you at each hearing that you do have the right to be represented by an attorney, including an attorney at public expense if you qualify and request. All right, well, we're here for a docket call that I had scheduled because Mr. McLoud had requested a jury trial and I wanted to touch base and have you both submit proposed jury instructions, which I did receive. Thank you both. So what I want to do is I'm going to have ask the bailiffs to deliver to you two packets. One is the ones that begin with 2.1. Those are the preliminary, that's for defense counsel. The preliminary jury instructions, and then the 3.1, or the ones that start 3 point. Those are the final jury instructions that I would propose to give, so those will be for your review. Count 1, the defendant is charged with contravention, resisting, obstructing. That's a bit of a strange statute. There's no model jury instruction for that charge precisely. The prosecutor based it on 13.2, which I think is correct. Although I did amend the prosecutor's requested charge to add some language from 13.1 that is also a correct statement of the law, particularly the statement that the defendant must have actually resisted by what he said or did, but physical violence is not necessary. And then also, because Mr. McLoud, you've raised a lot of legal challenges in this case that I have denied. Typically, challenges on the law are for the court to decide and not the jury. And you wouldn't be able to present those arguments to the jury. However, because you're charged with resisting and obstructing the concentration officer, the lawfulness of the officer's actions is indeed an element of the offense. So I am required by law to instruct the jury on the framework that they need to decide that in. So I've included some language for that the prosecutor did not request. Obstruct includes the use or threatened use of physical interference or force or a knowing failure to comply with a lawful command. The defendant must have actually resisted by what he said or did, but physical violence is not necessary. Defendant is a member of a Native American tribe that is a party to a federal court consent decree that binds the state of Michigan and its law enforcement officers. Under the terms of that consent decree, tribal members operating boats or other vessels who are engaged in the exercise of a treaty-related hunting, trapping, fishing, or gathering activity shall not be subject to state vessel registration requirements, provided that the tribal member satisfies tribal license requirements for the activity in question, is in compliance with the applicable tribal hunting, trapping, or fishing season limitations and tribal law adopted pursuant to the decree, and possesses evidence of being currently engaged in hunting, trapping, fishing, or gathering, such as fish, game, or common items related to hunting, trapping, fishing, or gathering, such as fishing rods, tip-ups, firearms, traps, or nets. Fourth, that the defendant's actions were intended by the defendant, that is not accidental. So in instructing the jury on the framework for which they should consider whether the officer's actions were lawful, I'm including in that instruction black letter law on reasonable suspicion and probable cause for a stop and rest, and I've included the direct quote from the consent decree that I believe is the provision that you've been arguing, Mr. McLoud. Mr. Juliet, do the people have any objection to that instruction?
No, Your Honor.
Mr. McLeod, do you have any objections to that instruction to the jury for the trial? And then in count 2 is the operating a motorboat while intoxicated. My model instruction is not that it was requested by the prosecutor. I model it on the OWI vehicle as did the prosecutor. However, the charging document in this case, the information, there's 2 ways to charge someone with operating while intoxicated. One is an under the influence theory, and one is a over the limit theory. The information in this case did not include the over the limit theory. It included only the under the influence theory. The test is whether, because of drinking alcohol, the defendant's mental or physical condition was significantly affected and the defendant was no longer able to operate a motorboat in a normal manner. Mr. Juliet, do the people have any objection to that instruction?
No, Your Honor.
Mr. Battelle, do you have any objection to that?
I'd like to include visibly impaired in that like the law says.
You'd like to include visibly impaired as a lesser included offense?
No, I'd like the language to include that, like the law states, that I have to be visibly impaired while operating.
Well, visibly impaired, operating while visibly impaired is a lesser offense than operating while intoxicated.
But the statute under the conservation, section 8 says this only pertains to a vessel that is being operated while visibly impaired. It's written in
Yeah, subsection 3, a person shall not operate a motorboat on the waters of the state when due to the consumption of alcoholic liquor or a controlled substance or both, the person's ability to operate is visibly impaired.
Ability to operate is very correct.
Right.
And then I'd like to include number 8 from that same.
Oh, the definition of operate as used in this section, operate means to be in control of a vessel propelled wholly or in part by machinery while the vessel is underway and is not docked at anchor, idle, or otherwise secured.
Correct.
All right. I will include the definition of operate under subsection 8 under the second element where it says second that the defendant operated a motorboat in the waters of the state. Operate means, and then I'll give the statutory instruction. But Mr. McLeod, the operating while visibly impaired is a lesser offense. So I can instruct the jury if you request, and I can change the verdict form to this effect too. It says that they can consider whether you're guilty of the operating while intoxicated, or they can consider the lesser offense of operating while visibly impaired. The operating while intoxicated is a higher burden to prove. The language under the influence of alcohol legally is a higher burden than the visibly impaired. So sometimes defendants want the lesser included as an option. Other times they don't because they don't think that the higher burden would be met. But so what I would not do, I would deny your request to combine them into one instruction. But if you want the visibly impaired given, that's a lesser offense. And I'll let you think on that. We're going to come back for another docket call in July. If you request a lesser included, we'll do that. A couple other things for jury selection with Mr. McLeod representing himself. I think the law does allow the court to conduct a voir dire, and I'm going to go ahead and do that. So I'm signing an order today that on my own motion, I will examine the prospective jurors during jury selection and not allow direct questioning from either the prosecution or the defense.
I object to that.
Noted and overruled. But I'm giving both sides, as required by the court rules, an opportunity to submit written questions. So you have to submit written questions to me not later than Tuesday, July 2nd, so I can review them. And we're going to come back for a docket call on July 9th at 9:30 a.m. And then I will not ask questions that I determine are improper, irrelevant, or unnecessary.
I'm sorry, you have a jury of my Native Americans, my peers.
No, sir. It's a jury selected at random from folks in the county. All right. And also, Mr. McLeod, you've waived your right to counsel, and we've gone through the waiver process, and I believe that you have knowingly, voluntarily, and understandingly waived the right to counsel with your eyes open as to the risks of self-representation, that you're choosing to exercise your constitutional right for self-representation. That, of course, doesn't allow you to become disruptive to the court processes. You've not been doing that of late, but there was some history early on of that. So under Supreme Court precedent for Florida v. California in 1975, this court may, even over objection, appoint what's called standby or advisory counsel to aid you if and when you ask for help, or to be available to represent you in the event that the termination of your self-representation is necessary. So therefore, on my own motion, I'm appointing the Sheboygan Office of Assigned Counsel, not to act as your attorney, Mr. McLeod, but to act as what's called a standby or advisory counsel. So they'll be present at the hearing in July and at the trial. That they won't participate. They'll be there to give you advice if you have any. If you don't have any, they won't give it. And then if, for example, you became disruptive during the trial to the extent that even despite warnings, you persisted and had to be removed, then the attorney would jump in and finish the trial on your behalf. But as long as you're not disruptive, that's not going to be an issue. But they're there just as advisory counsel for you.
I object. I want to represent myself.
And I'm going to let you represent yourself, but I am going to appoint a standby or advisory counsel just to assist you if you deem necessary. And then I did notice as I reviewed the witness and exhibit lists that were submitted by both parties, Mr. McLeod, you had listed both magistrates in the district court judge, probate court judge, the elected prosecutor, and a retired circuit judge. Can you tell me what?
It's all pertinent to my situation.
In what respect? What testimony do you think that they'd be offering would be relevant at the trial?
Do I have to tell them to say all that right now?
Yeah, you got to tell me that it's relevant, because I don't see how that's possibly relevant.
Well, the magistrate and the prosecuting attorney went ahead and prosecuted this case without having a warrant on file. The judges all looked through this file, didn't have a warrant on file, still pursued it. So I mean, it's kind of like your job, isn't it, to make sure all the paperwork's in order?
Sure, but that's not relevant to what the jury has to do. What the jury has to decide is whether the officer's actions on that day were lawful, and whether you were resisting him and or operating a motorboat while intoxicated.
Not guilty if he is guilty of a charge.
One more outburst and you'll have to leave. So the judge's testimony, magistrates and prosecutors, not admissible or relevant. So I'm going to strike from your witness list Magistrate Ellenboss, Magistrate Libby, retired Judge Spartan, Judge Vizina, Prosecutor Goodrich, and retired Judge Pavlich. So you may not call those folks as witnesses. Both have until July 2nd to file witness and exhibit lists, to file requested questions that I would ask the jury during jury selection to achieve a fair and impartial jury.
We're not going to get a fair and impartial jury because they're not going to be Native Americans. It's the whole situation.
Well, that doesn't, if somebody's African American, we don't see an entirely African American jury. If somebody's Asian American, we don't see an entirely Asian
It's
American
not
jury.
sure, not yours.
It's not, well, sure.
The argument that I'm fighting is based on the treaty rights. That's the whole thing about it.
Yeah, in fact, it would violate the Constitution if I tried to seat a jury of only Native Americans and excluded people based on their race. So I would decline your invitation to engage in racial discrimination in jury selection. So you have until July 2nd to submit written questions, and we'll come back for a hearing on July 9th at 9:30 so I can tell you which of those questions I'm asking or not asking. I'm granting Mr. McLeod's request to add the definition of operating And we'll give him until the 9th to decide if he wants the lesser included or impaired instructed. And we are still scheduled for jury selection August 8 and 9. All right, anything further for today from the people?
Just briefly, Your Honor, while we're on the record, Mr. McLeod and I have been undergoing continued plea discussions. I know in the past with some cases we've done a plea to a felony with a very short term of a delay with a dismissal at the end. Is this the type of case the court might consider something like that on?
Yeah, I mean, from what I've learned about the case in the pretrial motions, although your legal arguments have been unavailing, Mr. McLeod, I don't think your underlying conduct in this case was all that egregious. And so, I mean, I'm not looking to lock you up, even if you're convicted after the trial. So whatever negotiated outcome you guys could come up with, I would have no problem with. I don't think your behavior was extreme.
Can I motion for summary judgment?
What's that?
Can I motion for summary judgment?
Well, no, I mean, you already did. There has to be like legal grounds to dismiss, which I've denied, or that there's not enough evidence of probable cause to go forward, which I've denied. There is probable cause to go forward to a jury. So I can't decide it instead of the jury. I mean, you could waive your right to a jury and have a trial in front of me, but both sides would have to agree to that. Or if you wanted to enter a plea of guilty or no contest, the charges or some lesser charges as the prosecutor and you sort out, you can do that as well.
Well, right now what he's proposing is disturbing the peace with no probation, no jail, and a week delayed sentence to get it out of the record. I would like to add to it, find some cost because I already paid to drug testing and all that stuff for the first 4 months. And I'd like to also add to it that the week delayed the time served because of the time spent on drug testing.
All right, well, and if you guys come up with a negotiated outcome, then there are things that you both can agree to, and then there's things that you can leave. If you're not agreeing to them, that you both can argue to me, and then I can decide,
Well, that's where we're at right now. Let's do it right now.
All right, so I think what we'll do then, just because I'll indicate that the July 9th hearing will be a plea cutoff as well. So if there is any kind of...
Well, I guess what I'm wondering is if I take this plea and something.
Well, I haven't heard clearly what the plea would be.
Well, I guess he's accurate that I did offer a disturbing the peace, but I know this court doesn't do misdemeanor probation, so I think it would have to be a plea to the 2-year on a week delay with a dismissal at the end. It's technically felony probation. I'm willing to give him a disturbing the peace, but again, I don't think this court would put...
Wait, you want to do a disturbing the peace with a delay and dismissal?
No, well, I'm fine with that, but I don't think this court will do a misdemeanor probation.
I would do a misdemeanor delay with a dismissal if it's a short delay, and I wouldn't have Department of Corrections supervising. I would just supervise it internally with court staff.
Okay, I will get that drawn up then.
Okay. If you reach an agreement and you want to come in before July 9th just to get it done, just contact court staff and we'll schedule a time for you to come. Any other questions, Mr. Julian? No. Mr. McLeod? Okay, all right, we'll be in recess. All right, good morning. We're on the record in the 53rd Circuit Court for the County of Sheboygan, and we are providing public access both in the courtroom and also online. Our first case this morning on this morning's docket is People versus Trevor McLoud, file 23-6748FH. Counsel, you want to state your appearances, please?
Anthony Julia, on behalf of People.
And Mr. Wargo, you want to come on up? You've been appointed as standby counsel in this case.
Your Honor, my apologies. I'm not familiar with the standby counsel process, and I just found out about this morning.
Well, all right, that's not my issue. We appointed the Office of Assigned Counsel May 28th. Accordingly, in this court's own motion, the Sheboygan Office of Assigned Counsel is hereby appointed to act as standby/advisory counsel for defendant and shall appear at all hearings scheduled in this case, including the docket call on July 9th at 9:30 a.m. and the jury selection and trial August 8th and 9th. And the clerk's office would provide notice to standby counsel as well. Notice has been provided. We confirmed with your office that you were the one. All right, Mr. McLeod does not appear to be present in the courtroom. Is he in the hallway? He's not in Zoom either. He's not appeared. Have you had any contact with Mr. Trevor McLeod?
To my knowledge, the entire office is not, Your Honor.
All right, well, Mr. McLeod has been representing himself. I did appoint standby counsel at the last hearing. Standby counsel is present. But since the last hearing, Mr. McLeod has refused to accept mail from the court. We sent a mailing to him with copies of the orders that I entered at the last hearing. It was sent back to us with a red marker stating return to sender and offer to contract is denied. So sadly, Mr. McLeod seems to be retreating back into nonsensical sovereign citizen defenses. And he filed a document, or there's a document purported to have been signed by him entitled Letter Rogatory for Relief, that is legal nonsense that somehow accuses the court of somehow generating funds from the case using defendant as some security mechanism, which makes no sense at all. This is not the first problems we've had with Mr. McLeod, and now he's choosing to refuse service from the court and refusing to attend here today. We have a jury trial scheduled August 8th and 9th. Mr. Juliet, any requests from the people?
This is his first failure to appear, to my knowledge, but I wasn't aware that he was deliberately refusing correspondence from the court. So based on that, I would ask for a bench warrant.
All right, Mr. Wergo, any input from standby counsel?
Yes,
You don't represent him, but you're here to stand by and you're here to give him advice if he is here, if he wants advice, and to stand by to represent him if he's not able to represent himself, and him not being absent, I guess, if you want to say anything on his behalf, I'll let you.
Yes, Your Honor. Being that it is his first non-appearance, and it appears that he is maybe under the impression that there are some legal mechanisms at play that aren't, I would ask that instead of a bench warrant, the court issue a show cause and allow our office an opportunity to try and work with him.
Well, he's not only not here today, he's refusing to accept anything that we're sending him. He's repeatedly demonstrated contempt for this court's authority and process. I'll issue a bench warrant for his failing to appear with no bond. Do we leave the trial date on for now, Mr. Juliet?
Yes.
Okay. Normally, I would cancel the trial date. I'm going to give Mr. McLeod the courtesy of not canceling that trial date because I don't want him to be sitting in jail for a super long time on this case. But I guess my staff will monitor that. If he's not in custody soon, we'll be canceling that date and using it for other cases. All right. We'll be in recess till 10 a.m. then.